Right, I think we are live on Facebook. It's nearly 2 o'clock. It's 2 o'clock, Tuesday afternoon, and your favorite Party Wall show is on. So, good afternoon. This is Dil, the Party Wall guy, and it's question time with Dil, the Party Wall guy, every Tuesday, 2 p.m. Welcome. We are live on Facebook. Just about got it working. And let's begin. So every Tuesday we bring you a question time on the Party Wall Act. Let's have a quick run through of housekeeping. This is a Zoom webinar. It's not a Zoom call, so you don't need to come on the screen unless you really want to. Fire exits, the fire drill. So my fire exit's over this way. Not sure where yours is. Can't help you. Sorry. Make sure you know where your fire exit is, and if there's an alarm, it's the real thing. So please be prepared for that. If you're listening to us on the phone, you'll probably have a screen like this, and at the bottom, actually, I'm going to get my magic Zoom pointer one thing out. Get that started up. It's a good reminder. So on the bottom of your phone, you'll have that's to mute yourself. Put your hands up if you've got a question, and put your hands up if you'd like to say something or you want to raise a point. And there's your question and answer. So keep your questions coming in. And this stuff gives you the other stuff you do on Zoom stuff. If we lose web connection, we've got a backup here somewhere. Yeah, it'll take us about a minute or two to get on. If you're losing Wi-Fi connection, usually Zoom reconnects automatically. Recordings they're being scheduled on our YouTube channel, the 1996 Party Wall. So look out for those. They're going on a regular basis. So we record and we try and edit those out and put the full version on as well. We're getting into the swing of things. So there is a slight lag at the moment, but that'll catch up shortly. So my book, a couple of years ago, I wrote a book. Don't buy it just yet. Currently being updated. I'll let you know when the new version's out. We're also working on the Kindle version and the audio one. But tune into the show. Much better. We answer many more questions in much more detail. If you can keep your stuff on mute, but send us your questions and raise hands if you've got anything you'd like to discuss. Always happy to discuss stuff. So, quick introduction to myself. My name's Dil Gujral. I'm the Chief Surveyor at 1996 Party Wall. We're a specialist Party Wall surveying company. I guess it does what it says on the tin. If you'd like to send me questions, these are the best ways. Send me an email or send it to me on LinkedIn, as some of you guys have been doing. So, thank you for sending in your questions. The reason for the show, we're trying to, and I get surprised every time I hear questions, and sometimes from people that should know really much, should have more knowledge of this. We're just trying to put out educational content for on the Party Wall Act and how it works, and any questions that people come across are not sure about or just want a second view of, and as well as homeowners and people that need to know about it. So that's the idea behind it, and let's get straight into it. So if you can put your questions in let me get the question and Q&A box open as well. So if you can put any questions you've got, start them off, keep them coming in. It's always good to have questions. So that's what we're here for. We're here to answer your questions. Just keeping an eye on stuff coming in. So I've been doing a series of obvious questions that we get in the past, which is why, who, what, when, where, and how. So we've done why and who, what, which will be edited to put on our YouTube channel. This week, we're going to start by looking at when, but before I look at when, I just wanted to make sure we go through why again. So why undertake the Party Wall process? Okay. First reason is part of the process is to carry out our schedule of condition, which is a photographic survey, and it's done on your neighbour's property. So if you're conducting works, It's usually done on your neighbour's property, and that captures the condition of their property prior to works beginning. And this prevents false and malicious claims of damage that already exists. So a number of times we've gone into properties where there's existing damage, and you know, it's such in nature that we've had to look outside and just check that the neighbours haven't started their works. There's cracks where a steel, in the example of a loft, you're inserting a steel beam. I've seen cracks that would be put there exactly by less than careful builders, shall we say. So it could lead to you having to take the damage and take the responsibility of, as a building owner, someone who's doing building works, responsibility of damage that already exists. So this is why we carry out a schedule of condition. And it's very much similar to when you rent a car, they take photographs, log the condition of the car. So when you bring it back and you've done a Jason Bourne on it, there's no dispute as to whether you've done it or it was already there. So the second reason, and this occurs more frequently than we'd like, and it's very difficult. It makes our job much harder, but it also causes a lot of havoc if you're doing building works, and that's where the works get stopped midstream while the party rules process is sorted out. So don't make sure you try not to get into this issue. And perhaps this is the number one reason, and it's your responsibility as a building owner. You as the property owner who's decided to have some works done, it's your responsibility to make sure the party wall process is carried out. Very much similar to health and safety and some other laws that are strictly down to you. You can't delegate it. You can't say it's my architect's fault, it's my builder's fault, my project manager's fault. It's 100% your fault, your responsibility. And of course, by that, following on from there, you don't want to have legal action which escalates the costs and then creates increased costs for unraveling the situation, and you're going to have to do the process anyway. So why not do it in the first place? You know, save the time, save the hassle, save the money, and just get it done in a proper way. It's also the law. So it's, as I mentioned before, it's the law. So it's your responsibility as a building owner to make sure you comply with it. So today's little warm-up question, if you like, or today's part of the process as we're going through is, when should you take the party wall process? So usually when we look at project plans, we see something like this, whereby you've got people who have a plan, and the way they plan it is, well, we'll do the planning process. Once we've done the planning, got the planning, submitted the planning application, got the planning permission, then we'll start on the party wall process. This can be improved, and this causes extra delay, and you know, once the planning letter drops through, everyone's on a go state. So property owners have got their builders ready to go, and then they get informed by the party wall process and then say, we've got to wait some more. And the party wall process can actually be slightly variable. It can take anything from 1 week to 3 months, possibly even longer. So, and I had a question via email earlier on this, sorry, it was last week. So just at the back end of last week, I had an email discussion with someone, and his conclusion was exactly the same, that it's better to start the process, particularly if you're doing works under PD. So PD is permitted development, where you're doing loft conversion or rear extension. So it's stuff in a residential setting, you know you're going to get planning for it, or, well, it's actually an alternative regime. You know you're going to get PD for it. The better approach to take is to, once you've got an idea of the project, you've basically got a first draft. You haven't designed the kitchen, you haven't worked out the windows, but for all intents and purposes, you have an idea of the structure of the proposed project. You know where you're going to be excavating. You know, you have an idea of where you're going to be putting the steel beams in. You should really serve party wall notices at that point. Get the party wall process started. and then finish off and go through with the planning or the PD process. Now, this has a couple of benefits. So first of all, there's 2-month notice period, and the notice period can start running. Okay, so with loft, Section 2 works, there's a 2-month notice period. You can start the notice period running, and that will complete by the time PD or planning comes through. So that's one. Second issue you get here is, as soon as the planning application goes through, and that's start here, if you take it here, within a week, adjoining owners will start to get letters from other surveying companies that are marketing their services. And some of those letters are quite scary, some deliberately, some not so deliberate. And we've just, on a number of occasions, and I had this about a week or so ago, and currently dealing with it, where the lady said, look, we're great with our neighbours, that's fine. And she just had a lot of stuff going on. We had a chat in January. I'd advised her to issue the party wall notice as soon as possible. She said, no, fine, our neighbours are great. And I've spoken to the chap, and the chap's obviously a really nice chap as well. But because for a number of personal reasons, she'd had a number of issues going on, she'd actually forgot to start the process or told me to start the process. And what's happened is they've had the builders on site start works, and the neighbour's been demanding a party wall notice. So she's had to give them a party wall notice, or there's a threat of legal injunction there. And now he's actually, we served the notice, we've had to stop works. He's engaged another surveyor because I guess this is where you sort of lose trust in the right thing being done or not. So that was the case where she would have A, avoided expense, B, avoided hassle, and C, had to stop works, and it all would have gone like clockwork. Whereas if they just issue the notice sooner rather than wait for planning and forget about it afterwards. So it's very important in timings. Now, the other important thing on timing is this issue of non-response, and I'll talk about it under the 10-4 process. So this is what I mean by 10-4, and some of you guys might be old enough to remember the old CB days, CB radio, which talks about 10-4. It's not a phrase referring to that. It's a section number under the Act, section 10-4B. Basically, if you don't get a response, and a lot of professionals get this wrong as well, if you don't get a response, and it's 14 days for some notices, plus 2 days for service via posting, you should send a reminder letter, called a 10-4 reminder letter. There you're allowed 10 plus 2 days, again 2 days for service of the letter. So this brings you up to 28 days. And then after this, you should appoint a surveyor on their behalf. Now, it's quite important. You can't not appoint a surveyor, because that leaves you open to an issue in that you could potentially end up having to stop works midstream. So you have to close this loop. Now, under the Act, once surveyors are appointed, they can't be unappointed. So once you close this scenario, you appoint a surveyor on the adjoining owner's behalf. A, they can't be unappointed. B, they can't go and argue with you and appoint another surveyor. And so that completes that loop, and means that you can continue. Now, the other issue on this point, where you've appointed a surveyor on their behalf, this stops neighbours from frustrating works so it stops adjoining owners frustrating building owners or neighbours' works by not replying to notices. The idea behind the Act is twofold. On one side, it's trying to protect your right to do building work. So, everybody believes it's their property, they should have the right to do whatever you want, and the Act recognises that. And on the other side, as an adjoining owner, you're worried about the protection of your property. If you're sitting in your house, enjoying your property, rights of enjoyment, I think it's called under common law, and you're watching your iPlayer or YouTube or doing your Facebook stuff, nothing to do with next door. They're doing the works. It's not fair that you should have to deal with the damage caused by building works. And it may be a case that you have a good relationship with your neighbours, but it's the builders that are variable, and there's so many variables, other variables, including how the property was constructed. And some of our housing stock goes back to the Victorian times. So there's all these variables that maybe not be anybody's fault. So back to the point, the Act has dual purpose, making sure you can do building works on your property, like as a property owner, and on the other side, it's making sure that the adjoining owner is protected with their rights and isn't causing inconvenience, and it's not unfair on them. So that's the reasoning behind the law. Now, what if you don't carry out the 10-4 process? This is a frequent question, and the reasons for the problems you may get. As an adjoining owner, you might be unhappy with the neighbours doing something that they've got planning for, and as more and more planning becomes more liberal and more stuff gets under PD, and you've got 6 and 8 meter extensions being accepted, you might get frustrated, and it could result, if you avoid this notices and don't get engaged with someone, you could end up having no survey of your property. Therefore, you're losing some evidence as to whether the crack was there before or not, or the damage was existing. As a building owner, it's a little bit worse in that you could have your work stopped. If you don't follow the 10-4 process through, you could have your work stopped and pending while the party wall process is sorted out. And also it puts you on the back foot in terms of your legal standing, because you've actually failed to comply with the law. And the usual response of, I didn't know about it, or no one told me, or my architect didn't tell me, it doesn't actually carry weight, because in the eyes of the law, you're deemed to know about it. So ignorance of the law is not a defense. And on that point, there's a little section on architects. So we usually get 3 types of architects. There's the architects that on most planning people's planners' drawings, whoever you use, you'll always see a party wall note. You look carefully, it's in the drawings. So this group of architects usually bury their head in sand, put it in the notes, and say, if the client doesn't pick up on it, it's their fault, or we don't want to get involved, because it's a difficult conversation trying to explain to them. We're quite happy to explain to building owners, and particularly residential owners who are doing extensions and loft conversions for the first time, how the process works. We're trying to create material on YouTube, and this is some of the reasoning behind doing this, these webinar sessions. The second type of architects we notice, second group, is and these guys are really trying to be helpful. So they'll draft a notice and they'll give it to you to serve, and they'll say, here's a notice, you need to serve this. Now, with building owners, you get a horrified look saying, what do I do with these things? And what happens if there's no reply? And, a number of other questions they don't really understand. So it's a bit like giving, as you see on this little picture, someone throwing an X at somebody else and saying, how do we do this stuff? And on the last section, you've got architects who carry this out. But because every property and every project is slightly different, they do party wall work, but they can get stuck. So we do get a number of inquiries from architects, and we're quite happy to have a discussion with them and help them through issues that they're not come across before. So always happy to talk about party walls and discuss any points. I have to take you through this list because these are the top 7 mistakes we see being made by professionals, and not just architects, but predominantly architects, because unfortunately they get the blame for this because they're their first point of contact from clients. So you need to tell your client as soon as possible about this, because they will have to deal with it and then take trouble, right? They don't, so the other thing that the next biggest mistake is they don't know who the adjoining owner is, and they don't do a land registry search to get their details. So that's how you officially get the details. And there are various issues with doing this. Leaseholders between 1 and 7 years can get missed, but this is how the process works. And if you comply with this, you can then sit there and argue in court, we follow the process, and you've done everything you can. The other thing they do is they'll give notices to their clients only and say, here you go, serve these. They don't send them by certificate of posting. They don't follow the proper process. So that's a case of you either do it all fully, completely, or don't do any of it and say to your clients, look, you need to get help on this and make sure you do it properly. Again, this links it with this, where they don't follow the 10-4 process. They'll give a notice and say, what do we do next? Don't know. And part of the 10-4 process is to post out notices. And here I go again, certificate of posting. I think I should get £1 for every time I say that. Part of that is they don't complete the process. They don't send the follow-on letter. They don't appoint a surveyor on their behalf. And the biggest error we get, and every time I go to the post office, I get asked this question, especially because the regular post office I go to, he realizes what I'm doing. So he'll just ask it for fun now, actually. But everybody wants to send it by recorded delivery because they think that's the better way to do it. Wrong. Certificate of posting. Difference between certificate of posting and recorded delivery. Certificate of posting is actually cheaper, but the reason for doing it, it's only pennies, right? The reason for actually doing certificate of posting is if you did recorded delivery, postman turns up, Mr. Postman turns up, Mr. or Mrs. Postman turns up, knocks on the door, no one's at home. All right. Currently, everyone's at home or were at home, but increasingly people are at work. But they turn up, knock on the door, and no one's in. So there's send a little red tab, recorded delivery, pick it up, and then people are busy, they forget to pick it up, or it's a week before they pick it up, or they think more frequently it's just a bill. I'm not going to ignore this. I can't be bothered to take it. So if you don't collect it, if it's not signed for, that notice is not served. Compared to a situation where you put it as a certificate of posting, it's deemed to be served on the second day. That's why you use certificate of posting. And there you go. As we were discussing earlier, obtain and more importantly, keep for evidence. So you keep a scan of it saying, and everything you do, you've got to do as a legal process, because what you're trying to guard against is being taken to court. And these are some of the steps that we take to ensure our documentation is correct. We follow the correct process. And if it goes to court, we have the evidence. So this is the reason for obtaining and keeping certificate of posting. Okay, this was a question I addressed that last week. I've got some questions coming in, so I'm going to have a quick look at those that have just come in. Sorry, okay. Great question. Who would select third surveyor? A, adjoining owner surveyor, B, or building owner surveyor? This part of the process is very unclear, as adjoining owner surveyors always tend to fire out selection surveyors without waiting to hear from the building owner. So third surveyor is where you've got a situation where you've got building owner surveyor, adjoining owner surveyor. The first job they have once they exchange the letters of appointment is select a third surveyor. Now, a third surveyor doesn't mean you've got 3 surveyors charging you money. Okay, third surveyor is a role which stands there just in case the 2 surveyors can't agree. And the 4 people that can access the third surveyor are the two surveyors, building owner, adjoining owner surveyor, the building owner and the adjoining owner. So they can all have access to the third surveyor. And this is a change from the 1939 Building Act to the 1996 Building Act, where any 4 in the 96 Party Wall Act, any of those 4 parties can refer to the third surveyor. In the old London Building Act 1939, which is a predecessor to the Party Wall Act, it was only the building owner and the adjoining owner surveyor can access can ask something from the third surveyor. So back to the point on the third surveyor. Usually it's got to be a selection between the 2 surveyors. Usually the protocol is the building owner puts forward names. Building owner surveyor puts forward names. The adjoining owner surveyor may reject them, and the adjoining owner then can put forward another 3 to 6 names. And then if they can't reach agreement, they have to go to an appointing officer in local authority. It's very important to appointing a third surveyor is becoming a bit of a hot potato, because third surveyors are important, and you should try and choose the right third surveyor for the type of work it is. Sometimes and not always because of the geography, so you don't want someone miles and miles away. And thirdly, you don't really want a third surveyor that's busy, doesn't come back, because that can lead to frustration by the building owner. So those are some of the factors that you look at. My understanding is that protocol means that the building owner surveyors puts forward the names first, a list usually of at least 3, and then the adjoining owner surveyor can select from those, or if not, put back another list. And then once you've gone twice, then then you should go to the appointing officer. And sometimes the appointing officers don't know this is under their jurisdiction or it's the duty. So it's under section 10, and I think it's 10.8. So that 10.8 rings a bell. So there's section numbers in the act. That's where you need to look as to if you can't agree what you do. So I've got a few more questions coming in. If extending on the top of an existing ground floor, does section 2 apply? If extending on top of an existing ground floor, does section 2 apply? Right, a little bit more clarity on that one. Not quite sure what the question is. So if you're extending on top of a ground floor, does section 2 apply? The question could be several things there. Are we doing an extension on top of a rear extension? Does section 2 apply? Section 2 only applies if you're cutting into the party wall and there's a party wall structure there. So, I mean, it could, if they mean if you're putting a loft conversion on a bungalow, yes, section 2 would apply. We've got clarification. So section 2 could apply, and it might be a reference to section 1 in terms of rights of access. So if you could resend that question, it's not actually very clear. Is there a certain clause that can be put into an award which restricts the adjoining owner from carrying out any works along the party wall side at the same time as building owner to prevent any negligent claims or any dispute? So I'm guessing where they're looking at doing the works themselves. If they're doing any, no. So the Party Wall Act only controls notifiable works. So if they're doing other works, then if they're carrying out different works at the same time, then you can only, the party wall process only applies to notifiable works. So you can only control notifiable works. And if they're carrying out works at the same time as the building owner that are not notifiable, then it's for the individual parties to ensure that their own works aren't going to cause problems to their property. Whereby if you've taken a schedule of condition and they've done works to their property, it should be fairly obvious that they've done work, so it could be their fault. And I'm guessing what the question is asking is, can you stop them doing works? You can't really stop them doing works, but if the adjoining owner is doing notifiable works, they also need to follow the party wall process and serve notices. So you do get the occasion where both sides are going to do works at similar times. Next question: if building a double-story side extension and the neighbor has a timber fence about 200 meters from the proposed extension, and the neighbor wants to access it in the future for maintenance and painting, and there's not enough space after the extension is built, how would you go about it? So what they're saying is, there's your boundary line of junction, and there, 200 mil. The neighbors, the adjoining owner's got a fence, and you're going to build your building so it's right on the edge of the boundary, which means there's only 200 space left for them to access their fence. Unfortunately, in this scenario, it's a little bit. It's unfortunate for the adjoining owner if they can't get access to do paint and maintain their fence. they could do one of two things: take the fence out and move it further into the land, take the fence out and just use the wall as a boundary. So that's assuming that you're building right on the boundary. Now, there is another piece of legislation called Access to Neighbouring Land Act. That's where you're doing maintenance on your property. So if you've only got 200 mil and there is no building on the neighbour's land, they can obviously get access to maintain the fence. But the building gets built, you can't really stop the neighbour. It'd be unfair. It's allowed under the act, and just because you want to maintain a fence, it'll be unfair on you as a. If the roles were reversed, you'd say it's unfair. I want to build on here. So just when you get these situations, although it's not always the case, usually laws about being fair, and you have to sort of flip the roles. Does an architect need to register with the faculty or party wall surveyors to act as a party wall surveyor? Is it mandatory even if the architect is experienced party wall matters and act as a party wall surveyor in numerous party wall awards? Okay, so if an architect does party wall work, and do they need to register with the faculty of party wall surveyors? So, quick introduction to the faculty of party wall surveyors. I'm just going to put this little slide up there. I was going to go talk through a bit further on, I think. Right. So this is a government booklet. It's been updated, but the only thing they updated was the color of the cover. They haven't actually updated any content. At the back, you'll see a faculty of party wall surveyors. This is a professional organization which trains party wall surveyors. When this legislation came in, the government was very liberal in terms of who could act as a party wall surveyor. And this is some of the reasons you're getting the problems now. They didn't specify a qualification. The only two people who can't act as a party wall surveyor are the building owner and the adjoining owner. So anybody else can be a party wall surveyor. Now that actually causes a lot of problems, because a lot of surveyors don't actually know what they're doing, and this causes issues. Even some of the surveyors who think they know what they're doing don't actually know what they're doing. And this is the reason why the faculty of party wall surveyors was set up. It's a training organization. As a surveyor, I would say it's really worth joining them, or at least attending some of their trainings. I was on a training last week with an eminent barrister. Really interesting question. Prior to that, I was having a discussion with a friend of mine, actually, another party wall surveyor, and we disagreed on some points. Stuart Frame, who was the barrister, actually answered that question. We put it directly to him. So you don't actually have to be a member of the faculty of party wall surveyors. A, it helps. B, their training's really good, so it's worth turning up to their training. And now they're doing a lot of stuff on Zoom. So they answer very intricate, very detailed questions and go through law. CPD is always good, so you need to keep abreast of it. And this is where, because this law is changing and you need to keep up to date with current practice, you should always take some sort of training. So hopefully that's an unbiased answer. I'm not going to go and say employ me each time. Another question. I'm appointed as an adjoining owner surveyor for the freehold. The building has 3 flats, each with long-term owners, and they have their own surveyors. What would be included in the award between the building owner, adjoining owner, and a freehold? Do these have copies of schedule of condition of all 3 flats? Okay, so if you're appointed as a freehold surveyor, there's 3 flats, all 3 flats have their own surveyors. The pre-runner question to this question is, I'm thinking, why have 3 owners, leasehold owners, been appointed or served notices? A few years back, well, more years than I'd like to remember, actually, it used to be the case that if you're doing an loft conversion and there's flats next door, all the flats were served notice. Now, the application of the Act is changed. It's simply the flat next door and the freehold building. And again, on a rare extension, same scenario, leaseholder there and the freehold of the building. So the first question I'd say is, I don't think those three owners should have been served notice, but it depends on the works. So secondly, do these have copies of schedules of condition? Well, you can only do a schedule of condition where you can get access. So if you've got the copies and the demarcation between a freehold and a leasehold is the interesting point. Unless you're adept at reading leases, you can't really work out what they're responsible for. Generally speaking, it's a sort of you have to make the assumption that leaseholders are responsible for everything paint inwards, and the freeholders are responsible everything from paint outwards, the structure of the building. So it's quite a complex question. If you can get access to do the schedule of condition on the flats, that'd be useful. If they've got their own surveyors, might be an idea to talk to them just to make sure they've got it. Again, back to the earlier point, schedule of condition is there to protect both parties. Okay. Regarding extending of a top ground floor, 4 shops on the bottom, it is being proposed to put 19 flats on the top. Will a section 6.1 apply here, because they will have to excavate, but also wanted to understand section 2 applies as they're planning to build on top. So yeah, a little bit more clarification on the earlier question where you've got, I believe you've got a 4-story building. Let me read that again. Ground floor has 4 shops on the bottom and it's proposed, okay, so you've got ground floor, 4 shops on the bottom, proposed to build 19 flats on top. Will section 6.1 apply? Because they will have to excavate. Yes, so if you're excavating, section 6.1 applies. Even if you're excavating to lay drainage internally to your building, you still have to issue a section 6.1 notice. So the section 6.1 applies. Again, leaseholders and freeholders of the adjoining section. Will section 2 apply? Now, section 2 only applies if you're cutting into the party wall structure. So in this scenario, if you're going to cut, i.e. if you're going to remove a chimney or you're going to do some other works to the party wall work, it will apply. It could also apply if you're going to raise the party wall. So where you've got 4 shops on the ground floor and you're putting on a couple of stories and there's other shops next door, assuming you don't own all of the shops and you're going to be raising the party wall. So that would come under section 2, raising the party wall. We'd have to look at the detailed plan for this, but you know, it sounds as if section 2 would apply in this scenario. Okay, next question. Building owner is doing a rear extension, loft conversion, and an internal beams on all floor. I guess it's to an earlier question. Oh, okay. So this is a reference to where there's flats, and one side's got 3 flats in a building. Yeah. So yes, if you're doing a rear extension, you've got the leaseholder on that side. If you're doing a loft conversion, the leaseholder on that side, and if they're putting beams in the middle, the leaseholder in the middle. So that's probably why you've got a scenario whereby all 3 leaseholders have been issued a notice. So thank you for that feedback. Excellent. Does the adjoining owner, freeholder and leaseholder awards differ? Does the freeholder award contain leaseholders? Right, so do the leaseholder and adjoining awards differ? Yes, because they're freeholders and leaseholders, so obviously they're all and the names and their property titles are going to differ as well. So if it's number 5, you'll have probably the flat will be 5A or 5C, so you'll have 5A, 5C, and freeholder of the 5 will be 5 freeholder, and also the details will differ. the schedule of condition. Now, do you put the schedule of condition of the flat in the freeholders? Not really, because you'll get into GDPR problems. It's their property and it's their access rights, and when you're accessing for schedule of condition, you have to be careful of GDPR, where you can end up disclosing the personal. Look, white walls look the same, but you're going to also end up capturing, possibly in the corner, some photographs or personal information and so on. So be aware, you shouldn't actually include schedules needlessly, and especially in this scenario, whereby the property actually belongs to somebody else, and if there's damage, the leaseholder, will be chasing the parties doing the works anyway. So it is a good idea if you've got access. If you can get access and you're working for the freeholder, you should request it. So that's also a good idea. Excellent, great questions. I've had another question in, and this is a super interesting one. This will be the last question, I'm afraid. It's been a busy week this week, actually. So, great question. When does Section 6.1 apply and Section 6.2 apply? So 6.1 generally applies if you're excavating within 3 meters and going to a lower depth. 6.2 applies if you're 6.2 is whereby you have to notify properties within 6 meters, but only if they form a 45-degree angle. So an incorrect way of thinking about it, but this is the shortcut, and I get told off for putting the shortcut out there. If you're excavating less than 3 meters, it's 6.1. If you're excavating between 3 meters and 6 meters, then it'll be the distance you're excavating will any adjoining owners captured within that circumference, radius, sorry. So if you're going 4.5 meters, you form a 45-degree line, and it's 4.5 meters, any adjoining owners within that 45-degree line. If you go to 6 meters, you'll form this 45 degrees angle. So 6 meters, properties within 6 meters, they're notifiable owners. If you're going deeper than 6 meters, doesn't matter how deep you go, you form the actually, sorry, forget that. Forget about the 45-degree line. It's just adjoining owners within 6 meters of that excavation. So hopefully that quickly answers your question. Been an actually really interesting session this week. So look forward, before we go, here's some, this is a piece of work we did because the draft notices in the previous booklet weren't the easiest to use. So we created a little booklet for everybody to use. You can get it if you connect with me it's on my LinkedIn account, or send me an email. I'm more than happy to send it to you. And before we go, not quite last or least, we'd like to bring on one of our sponsors with us this afternoon. If I can get the tech working, that is. Mr. Ranjit Singh from Property Investor News, great magazine. Are you there, sir?
Yes, I'm here, sir.
So thank you first of all, thank you for sponsoring our program.
You're welcome.
And firstly, thank you for being with us. So if you could give us a couple of words of, usually a couple of nuggets of wisdom, and also tell us about your magazine. And I've got to update the slide, so that's an action point for me.
You want to share it so I can put the slide on?
Yeah, the slide. Oh, okay, screen share, right. Watch out for this.
I've got an up-to-date.
This is where it can. This is what happens when you do live programs. Right. Can I give you rights to share? Have a go. I'm not sure if you can share, if I can do that. So, oh, hang on. Yeah, I've worked out the tech. I know how to do this. Allows the. Allow participants. Have a go at sharing screens. You should be able to do it.
Host disabled attendee screen sharing. So you got to.
Okay. Mark that up. Hang on a second. I think I've done it, but have a go, sir.
Let's see. Can you see it?
I can see you, but I can't see the screen. So.
Oh, it's still disabled on your side.
Okay, hang on. Let's see. Spotlight video change.
You did it last week.
Yeah, I managed it last week, so I'm gonna let's see if I can get this right. Hang on a sec. I'm gonna hand you over control if you promise to give.
Okay. Yeah, I think that's what we did last week.
There you go, guys. Right. Let's have your screen shared. Way.
Can you see it now?
We can indeed.
Yeah, that's with the on your bike issue, the purple one with the little bike on it.
Yeah, is that a hint?
Is that the one you can see? Yeah.
Yes. Is that a hint or something?
What's happened here?
I didn't do it. Yeah. No, you're back on screen. Yeah.
You can see the screen, yeah?
Yes, we can see the screen now.
Okay. Good afternoon, everybody. My name is Ranjit from Property Investor News. A new world ahead for the bold and the brave. Education is the only weapon to be successful. No matter what business you're in, property is no different. Prepare yourself for the changes, challenges ahead and the opportunities. Become educated, knowledgeable, informed investors. Our publication provides analysis, news, research on property investments, also updates on mortgages, finance, auction, legal matters, and much, much more. We do have a limited time offer only. Our June 2020 issue was 200th issue, which is on the screen in front of you. The special offer is receive 3 free issues plus 200th issue, so it's 4 issues for free, and also auction book Before the Hammer Falls, written by 2 auction experts. The main theme in our July issue is On Your Bike, COVID-19 accelerates the trends of healthier commuting to work, and much, much more. To subscribe, just follow the instructions in the chat box or take the details from the slide in front of you. Go to our website, subscribe, and you must send me an email saying that you have subscribed with your name, address, and the long reference number you'll receive. I'm going to leave you with the following. We are in changing and challenging times, and there are going to be setbacks. When you get a setback, don't sit back, only step back to bounce back. Behind every setback, there's an opportunity. Today's decisions are tomorrow's reality. Remember, you have 3 choices. Take it, leave it, or change it by design. It's your future. Remember, when you are finished changing, you are finished. Quote by Ben Franklin. Thank you for your time. Back to you, Dil.
Thank you very much for that. And if you, I do subscribe to the magazine. I don't get it for free, but it's a great magazine. And Mr. Ranjit Singh's very kindly send you guys a free book. The book's excellent as well, worth reading. Before I disappear, actually, I'm going to see if I can get back control on this thing. Yeah, actually, that's what I. Oh, okay, got it back. So I'm not going to change the screen. Before we finish off, actually, I've got another question coming in, so I'm going to answer this. Okay, Dil, with regard to my question, why is the emphasis more on the building owner surveyor to serve signed awards to both building owner and adjoining owner. Shouldn't the building owner surveyor serve the assigned award to the building owner and the adjoining owner surveyor serve on the adjoining owner? Right. So normal protocol is standard protocol. Building owner serves award to the building owner. Building owner surveyor serves award to the building owner. Adjoining owner surveyor serves award to the adjoining owner surveyor. That's standard protocol. And the idea, and I'm guessing the idea is they don't want to talk to you or your surveyor. So, it's a standard legal setup whereby everything goes to the surveyors, they talk to each other and comes back, a bit like barristers. On that front, that's the normal protocol. And sometimes surveyors agree, look, it's easier, you serve them both or I'll serve them both. So you can agree and you can do it. So you can do it, the building owner surveyor can serve both or the adjoining owner surveyor can serve both. And we get occasions whereby it's easier to do that. So that can be done. There's no harm in doing that. But the normal protocol, as I said, is each surveyor serves to their own. So if some adjoining owner surveyor saying you serve it and you don't want to, they are theoretically wrong. But as a building owner surveyor, if you put it in the post, you've got your certificate of posting, that means it's been served. So there is that advantage to it. So it's an interesting point, and I think that's there's someone who's pretty upset at the adjoining owner's survey from all the questions we've had with them. So and you have my sympathies, because it's really tough being a building owner surveyor. And I don't think you understand the role unless you actually do it. So hopefully that helps you there. I know it can be difficult. The only positive thing is once you're not relying on the adjoining owner surveyor to confirm the award's been served or sending you a certificate of posting, you actually have the certificate of posting yourself, and the award will be deemed served in 2 days. That's the positive bit. So once again, thank you for the really great questions. It's been a really interesting session next week. We'll see you next Tuesday, 2 p.m. Keep your questions coming in. Thank you very much.
Thank you.